Hello, welcome, welcome, welcome. So, I'm a bit disappointed today. As you can see, maybe you didn't notice, so let me inform you. The time of this stream was pushed back several times, and I really was looking forward to seeing you all today. No, our usual format is you being able to see me and, us being able to have a conversation. But despite my best efforts to find a replacement ring light today, it didn't happen. It didn't happen. And so that is why the time kept getting pushed back. And we're just going to have to wait for Amazon. And without the extra ring light, we just don't have the right lighting. So we are going to keep it rolling. We will do this stream by audio, right? But I do look forward to the next time that I'm able to see you all again. So let me get into the chat and say hello to everyone. Hello to Trip C. Hello to Castle. Hello to Akata. Hello, Shiba Mooncat. Hello, Shanoa Lorencin. Ooh, Lorencin? Beautiful name. Hi to Octavius Prime. Hi to Man King. And hi to Chief X. So, hello to Quack 13. You all already see what is on the docket for today. You see, we have two very important things we're going to get into, right? First, I believe I put that first in the title. Yes. Okay. Because we're going by order of the title. First, we have the Brother Polight case update. There have been some new filings in the case, so we're going to discuss that, right? And then we have a new lawsuit filed against Bill Cosby. So we're also going to get into that. All right, everyone. Sorry about that. I had to pause for a moment. Alrighty, so let me do some other hellos in the chat. Let me also say hello to Black Anonymous and, of course, hello to Mara Charisse. If you're just joining the chat, I was explaining that, life happens and life happened to us today. And so we're by audio today, and that's okay. Alrighty. Now, let's first hop into our very first topic, right? Which is the update in the Brother Polight case. I'm going to share my screen and we are going to head on over to the Miami-Dade clerk of the court and check out what they have listed as the most recent activity in the case. You're welcome for always saying your name correctly, Mara Charisse. And I want to say thank you to you and everyone else in the chat for always being so supportive. I started the hashtag lawyers have lives too. And it's true. We have lives, we have priorities, we have responsibilities. We have all these things that we have to juggle as well. And that's part of the reason that really I usually do my lives on the weekends. Because let me tell you guys, Monday through Friday is a zoo in my life. I mean, it's insane. It's just nonstop, nonstop, nonstop. And then sometimes when I do have my live schedule for the weekend, I'm tired, and I want to decompress and I want to chill. Or I have 50 million personal things to do that I wasn't able to do Monday through Friday. So thank you all for being here and being understanding always. I appreciate it. All right, so sharing my screen and taking a sip of my water. I'm virtually sharing that with you because I know that unlike our usual, you're not able to see me doing that. Oh, I shared the wrong screen. Share. Chrome tab, Miami-Dade. Okay, we're getting to Department of Justice in a bit. Okay. All righty, here we are. So let me take my little sip of my water. So this should look familiar to you, right? This is the Miami-Dade Clerk's Office website. We've been here before to take a look at the case and to look at the disposition chart. which shows you what's going on in the case, right? Hello to Negus Roselle, one of our members in the building. So big shout out to him. All righty. So I see Trip C and Black Anonymous are having a good little combo. I love that. I love when you all get to connect and everything in the chat. Let me actually log into the live from my phone. Oh my goodness. Perfect. So I can say hello to you all. Alrighty. So now let's get into it. So let me make this full screen. There we go. Okay. So the last time that we took a look at this case, we saw that there had been a motion regarding the bond status, right? And we saw that there was a request for a stay away order. And we also saw that there is a status conference set for December the 3rd. So all those things that happened in September, we are aware of, right? That's nothing new. Now, if you're new here, it may be new to you, but it's not new, okay? Now, let's see what has happened as of late. So, as of October 11th, we see that discovery has begun. How do we know that? Well, you see here, we see DISC, that is short for discovery. Now, one of the things that we love to do here is have moments where we can edify each other, right? Where we can learn things. So, this is a learning moment. Discovery, if you're unfamiliar with it, is the process by which the two parties that are engaged in litigation exchange the information that they have. So if it's a civil case that is the plaintiff and the defendant, right? If it is a criminal case, that is the government agency that is bringing the charges and the defendant. And so during discovery, it's a time period during which each side of the case shares information that they intend on using at a potential trial. Now, it's important that I clarify for you that discovery does not mean a trial has to occur. Oftentimes, after the discovery period, one party or the other makes a move to try to somehow rectify the situation, right? So in this instance, Mr. Nowak could still make a move to try to plea, or try to negotiate some sort of plea deal, I should say, right? This is still a possibility. Just because discovery is occurring does not mean there is zero possibility for some sort of plea deal to happen. That could still happen. And it's also possible that after discovery and after the defense sees exactly what evidence the government has, they may be more inclined to plea, right? You never know. Okay. So we're here. Line 26, discovery exhibit. Okay. State's demand for defendant discovery. So we know that the state issued a demand that defendant begin to exchange information with them, right? They specifically demanded alibi, right? And demand for notice of subpoena ducis tecum. Okay. So let's take that apart. Let's first discuss a demand for alibi. Now, per usual with this case, there has been a lot of back and forth about this demand for alibi. Okay. And many people think that a demand for alibi somehow means that, Michael Nowak or his attorney has said that he has an alibi. And I would like to let you know that that is not true. Okay. A demand for alibi is something that is par the course. It is the norm for a prosecutor to request that if the defendant has an alibi, so if the defendant is going to argue at trial, I was, in Vegas when this happened in Miami, then defendant has to let the government know about that alibi. So it is a normal procedure for a prosecutor to request that a defendant disclose if they have an alibi. One more time. If they have an alibi. Now, is it possible that the government thinks that maybe Michael Nowak has an alibi, or that maybe let me back that up. Is it possible that the government thinks that Michael Nowak may argue that he has an alibi? Yes, it's possible that they may think that, but they don't even have to think that to make the demand because the demand is just part of due diligence, right? Any prosecutor doing their due diligence, meaning doing their job in an effective manner, is going to issue a demand for alibi because, hey, you never know. And you do not want to get to a trial and have this defendant get up on the witness stand and say he wasn't even there. That looks terrible. And if he does do it, right, you should know it's coming. It is not something that should be a surprise. So, from the government's perspective, they almost always demand that if the defendant has an alibi, he disclose it. So, do not get up in arms about the demand for alibi. It means the prosecutor is doing her job. Demand for alibi is par the course in criminal case discovery. Okay? I'm going to stop sharing for a moment, hop into the chat to see if anyone has any questions for me or anything that you would like to address. Okay. Corey says, thanks for the clarity. You are welcome, Corey. All right. So I am just scrolling through. Hello to Michelle Jordan. Hello to Niqua B. Hello to Nappy Yankee. Where's Nappy Yankee? There he is. Hi, Nappy Yankee. How are you? How's it going? Alrighty, so I don't see any more questions about the demand for alibi. Is that correct? No one else has a question about demand for alibi. Going once, going twice. No? Okay, alrighty. So we're going to hop into subpoena deuces tecum. Okay? Alrighty, let's do it. I'm going to share my screen again. You just go ahead and remove that first. And as Nappy Yankee so eloquently says, like this video, share this video, and subscribe to Empowered Esquire TV. If you are a returning subscriber, hello, what's up? You know, here in the EE world, we call you an OG, right? And if you're a newbie, welcome, okay? Sable Do, I don't know. You let me know. Has a question. That kind of corners him? Well, it doesn't corner anyone, right? But what a demand for alibi does is it ensures that the government isn't caught off guard by a defendant reaching, perhaps a trial and then all of a sudden saying that he has an alibi. It ensures that the government is aware if the defendant is going to argue that he wasn't even there, because that's a big deal, right? Okay, share screen. We are going to hop into subpoena deuces tecum. So here we are. You all know we love to use the Legal Information Institute, or the LII, to define things. And you know that my biggest thing here on Empowered Esquire TV is to do what? To arm you with legal knowledge. That's why the channel name is Empowered, right? It's for you to be empowered. And so what I don't want to do is sit here and just speak at you with this random knowledge and make myself appear to be some genius, right? No, I'm here to teach you. You remember that old saying that, you can give a man a fish or you can teach him to fish. My goal here is to teach everyone on EETV how to fish. I'm teaching you how to go get this legal information for yourself, right? So you can be empowered and you can know it and you can still chat with me about it. But I want you to know what you're doing. That's what's important to me. So, off my soapbox, here, LII, Cornell Law School. So this is a legitimate institute. If you're an OG, we always go to LII, right? So subpoena deuces tecum. A subpoena deuces tecum is a type of subpoena that requires the witness to produce a document or documents pertinent to a proceeding. Okay, pretty simple, right? So, subpoena deuces tecum, and just in general, right, is a subpoena in which one party is requesting from another party that they produce some sort of documentation that is relevant to the case. So, because we can't see the exact discovery motion or discovery exhibit that was submitted by the government, right? We can't know for sure if there were specific documents requested. But what we can imagine is that there was definitely a statement of generality in there in which the government is saying, hey, defense, you need to disclose any relevant documentation that you have, right? So could it be that the government is aware of certain specific documents that they requested? Possible, right? But could it also be that they just made a general request for discovery? Also possible. We are not going to know for sure because we're not looking at the actual document. Okay? Now, Chief X has a question for us. His question is, Empowered Esquire, do you think they have text messages and calls? And is that brought out in trial or before? So, if the government has text messages and calls that they intend on introducing, that would be exchanged during discovery. Now, would we know about it? Maybe not, right? Because as we can see, the reporting from the clerk's office is very general. It's in very, very general terms. So there's no guarantee that we would really be aware of text messages and phone calls until there is an actual trial. But I can assure you that the government would have to disclose that to the defense. So whether or not we would know, you never know, right? But whether the defense would know, that is a for sure. They are definitely for sure going to be aware of that. Okay. So I have another treat for you all. I want to show you something. Share screen. So here we are. We are here at the Department of Justice Archives. Okay. So here the DOJ has created for assistant state attorneys a little blurb, which they recommend they use when they're demanding disclosure of an alibi defense. So even though we cannot see the exact document submitted by the ASA in this case, we get to see the gist of it, right? Okay, so here it is. To defendant, pursuant to Federal Rule of Criminal Procedure 12.1, you are hereby informed that at blank o'clock AM on PM, AM/PM on blank day of blank month at street blank, there was committed the crime of blank, with which you are charged by blank. Demand is hereby made upon you to furnish the U.S. Attorney with a written notice of your intention to offer a defense of alibi within 10 days of this demand. Pause. Notice that it doesn't say, we know you're going to say you have an alibi, right? Notice that it doesn't say, we heard you're going to say you have an alibi, right? Notice that. Notice it says, if, right? If you intend to offer, notice that. So it is your intention to offer. What does that mean? That means, hey, defendant, if you think that you have an alibi, if you think you would introduce an alibi at a trial, you got to tell me about it. So it doesn't mean that the government knows for sure there is one, right? Or even suspects there is one. It's just a sort of, hey, if you think you got one, you have to let me know. Okay, that's the vibe there. Now let's continue. In the event that you intend to offer a defensive alibi, okay, we're here in the second paragraph. Demand is also made upon you to disclose the specific place or places you claim to have been at the time of the offense, and the names and addresses of the witnesses upon whom you intend to rely on to establish such an alibi. Okay? I see there's something in the chat about the word blank, which that's funny to me. So let me explain that. If you're looking at the screen, you see that there's an actual bracket. That is blank. I don't know what you would want me to say unless you want me to make up random numbers to put in there, right? So if you see the bracket that says day and the bracket that says month, that is in effect, you all, I hope you're not hearing my dog going crazy. That is in effect a blank, okay? So if you're wondering what the blanks were for, it's for the brackets there, that should be the day and month of whatever the crime was. Okay. All right. So back into it. So the second paragraph, right? Now, here's what the second paragraph says in layman's terms. Michael Nowak, if you are saying that you have an alibi, then you also have to tell us exactly where you're saying that you were. Oh, and also, you have to tell us the names and addresses of any people that you think could verify, right? Any people that you think you would introduce at a trial to verify your alibi. That's the gist of the second paragraph, okay? So I'm going to leave this up on the screen as I hop into the chat and take any questions. You know what? I see that we have an issue, so I'm not going to listen. We're not going to do it. I don't have the blockety block song queued up, but let me be very clear to everyone who remains here. And I say this with love because y'all know I love you. Don't come into this chat being disrespectful, being passive aggressive. Let me tell you something. I've dealt with all different types of people, and we know passive aggressive behavior when we see it. Be respectful to everyone present, including me. That's it. It's zero tolerance for foolishness around here, or you get the blocketh. And my blocketh is forever. No foolishness. Now I see some questions. Corey says, knowing what you know about the trial/evidence, how would you try to defend Polight? Where is the state's case weak? So I am not going to answer that question, and here is why. Mr. Nowak has retained attorneys who I am sure will defend him effectively, right? And I am not going to do their job for free. All righty. The blocketh is forever. It is forever. And people love to come in here being nasty to my subbies and being passive aggressive. We're super intelligent over here. We know passive aggression. You don't get to do that. That's not right. So are there any questions about demand for alibi per the little gist of it that we just saw online, right? Per the suggested form of disclosure that we just saw online. Tripsy said, leave Our Lady alone. Y'all listen, with everything that I pushed and rushed and flushed out of the way to go live for you all today, I have zero tolerance for foolishness. Anybody who comes in with foolishness, with all of the sacrifice I make to be here, is a no for me, okay? Any questions about this defense for this disclosure for this demand for disclosure, goodness, of alibi defense? No? Okay, alrighty. So I see someone saying, what if he doesn't give one? Then he doesn't have one. He doesn't have to disclose an alibi if he doesn't have one, right? It's just that if he does, he has to disclose one. Hello, T Breeze. Hello, Fab 540. Hello, Empress Kaya. Hello to everyone. I just took my sip of water. Hello to Missy OCOV. Hi, Helmet Chili Gaming. Hi, Clean Black Sneakers. Let's see. We have a comment from Caramello Boto. I knew this was serious, but listening to the details just confirms that. I don't know how anyone can fall for the banana in the tailpipe. Interesting, banana in the tailpipe. Hello to some chick named Star, and hello to Zion Movements. Okay, so I don't see any questions. So we're going to hop right into Bill Cosby and this new Bill Cosby lawsuit. So I'm going to give you all 10 more seconds. If you have Michael Nowak, aka Brother Polight, questions, drop them in the chat. Otherwise, we're moving on to Bill Cosby being sued by another alleged victim of blank assault. All right. Negus Roselle says, hopefully he has an alibi right now because it looks real bad. We'll have to see. If he has one, he'll have to disclose it. Okay. All right. Yvonne Diva says, is he trying to say he has an alibi or is this just a routine part of the case? Hi, by the way. Hello, Yvonne Diva. I'm so happy to see you. So this is a routine part of the case. I know you're just joining us, but I kind of explained to everyone that from the government's perspective, it is par the course for them to request that defendants disclose potential alibis. It is something that should be done just to cover the basis as a prosecutor, right? To make sure that if in fact a defendant wants to argue that he or she has an alibi, you're aware of that. So doesn't mean he has one. It is a routine part of the case. All righty. Niqua, I think I said that right. And I see she also has a channel, right? Oh, by the way, wait, I'm remiss. Everyone, Yvonne Diva has a channel, so check her out, right? Let me do this before I forget. Black Anonymous also has a channel, so I'm going to do a quick little shout out to the content creators, right? Trip C has a channel. Nappy Yankee has a channel. Where is one of Nappy Yankee's comments? I'm lost in the sauce on the comments there, but Nappy Yankee also has a channel, and Negus Roselle also has a channel, so check them out, okay? Now, let me go back to the comments. So, Niqua says, will he have another court date before his December date? Probably not, but remember, in the realm of possibility, it's possible, but probably not. Okay. And Max says, I must be blocked. And Mac, you can't be blocked because we're looking at you right now. So I don't get it. What's going on? What's the fake beef going on here? Hi, Crime Spotter. How are you doing? Crime Spotter says, hey, folks, should he be online talking about stuff still? Aha, Crime Spotter, thank you for bringing that up. So if you are an OG here, you remember that at the last court date, the ASA said to the judge, Your Honor, defendant Nowak is online. He's saying things about this case online. And remember, the judge said he has a First Amendment right to an extent, but that he should be mindful not to say anything that would interfere with the case, right? So as long as he's not saying anything that interferes with the case, he's fine. Now, the judge did also say that if the ASA wanted some sort of order which bans him from social media, she has to submit a motion to that effect. And we don't see that she has. Okay, could it be in the works? Yes. Let's see. Yuakata says, will they ever post a settlement attempt? So in this instance, it would be a plea negotiation, and maybe they are negotiating a potential plea deal now. We're not sure, and there would be no way for us to know that, right? Okay, I am scrolling through, taking questions. Trips Treehouse wants to know if I got her Cash App. Let me check. Sometimes I get caught up, you guys. So let me check and make sure I give a shout out to anyone. Remember, if you send a Cash App and you don't want me to say your name, just put an NA in the description, and then I won't say your name on live, okay? Because I understand sometimes you want your privacy. I get it. So thank you to Trip C's Treehouse for the Cash App. Also, thank you to Tropical for the Cash App. T Tropical, okay? All righty, let's see here. Trip C says, what about the bond increase? Yeah, we covered that when we covered the court date. So if you missed that, there was a bond increase in our video where we review the last court date. You actually hear the judge go through each charge, and he states the bond amount on each charge. Hello, Brenda W. Good to see you again. Brenda says, if they were going to charge him for being at the park doing a live, wouldn't they have done so already for bail stipulations? Well, that depends on what his bail stipulations are. So if his bail has some sort of stipulation about being in certain types of places, such as, near schools or near parks, then yes, they can revoke his bail for that. However, it would have to be brought to the attention of A, the judge, and also B, the ASA, right? Because the ASA is probably the person that would make the judge aware. Chief X, also check out Chief X's channel, right? Check him out. Chief X says, do you think the prosecution team, in your opinion, is comfortable they will get a conviction because of DNA evidence? So in my opinion, I don't think that prosecutions or prosecutors, I will say, ever really rest on their laurels. And I'm going to tell you why. We are living in, despite what people think, we are living in a pretty liberal world, especially when it comes to our criminal justice system. And so I don't think that prosecutors ever really rest on their laurels, to be honest with you, because there's always the possibility that, the jury decides that they just don't like the government and they're just untrusting of the government in general. And for some reason that results in an acquittal. So do I think they're kind of relaxed right now and thinking they got it in the bag? I think they're working pretty hard at it. I don't think they're just relying on DNA evidence to make their case, in my humble opinion. All right. Trip C says, someone asked a question. She's reposting it. Wouldn't a forensic expert be called to identify the estimated time of semen? Interesting. Which would nullify an attempted alibi. That's very, very interesting. So, yes, it is a potential for some type of forensic expert to be brought as an expert witness, right? But not necessarily. Because remember, when a rape kit and all these things, shoot, I use the word, you guys, we're done. We're done. Miss Algorithm is coming for us. So you guys have to remember when our kits are completed, right? Those kits are completed by forensic analysis, right? And scientists, as well as medical personnel. So a host of professional personnel are involved in completing these kits. So could the government bring a witness? Oh, for sure. But could they also enter the report itself as a business record, as a record created by law enforcement and use the report itself? Yes. Now, if they want to be doubly sure, they would bring an expert witness and use that expert witness to enter the report, right? Which is a process called authentication. It's a process by which you have a witness say, oh, yes, I know this thing. Oh, that's the real thing, right? So they could, if they want to cover their bases, have an actual expert witness take the stand. But they could also just enter the report and rely on the report as it stands. I hope that I answered that question. If I didn't, let me know. Yuakata says, thank you for your expertise. Thank you, Yuakata. I appreciate you being here. We also got Black Godzilla TV in the house. Black Godzilla TV says, is it possible to see his bail stipulations? Probably not, right? Because you would need to actually see the case documentation, and that has not been released. You could, of course, look up general bail stipulations in that area, in that district, I should say, but it doesn't guarantee that you know the ins and outs of his actual steps. Okay. Nappy Yankee says, if it turns out that he lies about the alibi, could that speed up the conviction? No. If he discloses an alibi that turns out not to pan out, then it just doesn't pan out, but it wouldn't speed up the case in any way. And Mac, hi, M Mac, how are you? Your question was answered, I believe, right? Okay, good. Good, great. All right, so I don't see any other unanswered questions. So you all are ready to move on to Bill Cosby then. Going once, going twice. All right, so we're moving on to Bill Cosby. All right. So for those of you who are unaware, if you've missed it somehow, right, allow me to enlighten you. Bill Cosby is facing yet another lawsuit. As you all know, he actually faced criminal prosecution and he was released, right? He was released on what some would call a technicality, but no matter what you want to call it, he was released. It was deemed that his conviction was actually not proper and it was overturned. Okay, so being that he's no longer being held criminally responsible for certain things, it looks like people are coming into the idea that being that he is out and about and he is not imprisoned, then civil cases can be brought, right? So a lot of civil cases may pop up now because he is no longer incarcerated, and that kind of paves the way for victims who did not get criminal justice to seek civil justice, okay? And of course, victims, this type of term, it's all alleged, right? It's all alleged. We should know that by now. So you guys know here on this channel, We do not do random generalizations, right? And then like random gossip. We like to look at the actual case documents. So, of course, my surprise for you today is that I have the actual documentation from the lawsuit that was filed against Bill Cosby, right? That's right. Just like Africa Bambaataa, we're going to look at the actual lawsuit that was filed. Cool? All right, so let me go ahead and pull up the suit. Da 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 da. Make sure it's open. It is open. Perfect. And then I can share with you all my window so we can all see it. Share screen, window. Perfect. So now you should be looking wonderful. We're golden. Okay, good. All righty, so let us hop into it, shall we? So we're going to start, of course, here on page 1, okay? So we see that this case was filed in the District Court of New Jersey in Camden. And that tells us a few things, right? This case was not filed in a state court. It was filed in a federal court, in a United States District Court. Now, if you're a newbie here, this section of the case here is called a case caption, right? Why is it called that? Well, here's why. Because it tells you the gist of who's involved in the case. So you have Lily Bernard as the plaintiff, and then you have William Cosby as the defendant. Now, here you see jury trial demanded. What does that mean? Well, let me highlight that for you all. We'll use yellow, right? Okay, so why did it highlight it? Listen, do we have time for this tomfoolery today? Yellow, what? Did you see this? I'm done. So it says jury trial demanded. The woes of me trying to be fancy and give you all, fancy things like PDF highlights. Boy, I tell you. So, jury trial demanded means that Plaintiff Bernard is requesting that if this case goes to trial, an actual jury hear this case, meaning she does not want a bench trial. She does not want a judge to act as the fact finder or in a jury-esque position. She wants an actual jury of her peers to review this case if in fact it ever gets to a trial. Okay, now Trip C says, can we get some more likes free? Can we get some more likes, please? They're free. Yes. Can we? Can we get some more likes? They're free. But remember, you can also dislike because Miss Algorithm doesn't care, and so neither do we. Okay. You all haven't had anywhere near enough coffee today. Y'all know my tales of woe. Okay. It's Saturday night. Now, let's hop into it. So we see Plaintiff Lily Bernard by her attorneys Merson Law, PLLC, complaining against defendant William Cosby. Okay. Now she goes into jurisdiction and venue. Again, if you're a newbie here, this is new to you. And if you are an OG, just stick with us for a minute. We got to make sure our newbies are edified as well. Okay. So, in order for a court to hear your case, they must be the proper jurisdiction and the proper venue. Being the proper jurisdiction means what? That whatever your case involves and that wherever you are, they have the power over that area. They have the jurisdiction. And then being the right venue means that for your case and for your parties, this actual court, right? This location is the right location. Got it? Good. Okay. So this is the section where plaintiff has to establish that because remember, she has the burden of proof. She's bringing this complaint, so she has to be sure to tell the court everything they need to hear to make sure that she's actually where she should be. She's in the right place. So she says, okay, plaintiff is a citizen of California. I'm a citizen of Pennsylvania. The amount in controversy is over $75,000. Okay. And the court thereby has jurisdiction under this specific law. She then says, and this is the right venue under this specific law. Okay, those bases are covered. She gets into the parties, right? I'm not going to stay on that too long. Okay, and then she gets into the facts of the case. Okay. Any questions thus far? I don't see any. Um, Hello to Victoria Watson. She says, hello, I'm new to your channel, but I've been watching for about a month and I finally caught a live. Hello, hello. Thank you for your professional commentary. Thank you, Victoria Watson. Okay. So here we are, facts of the case. God forbid I try to highlight anything else for you all. You know, the whole laptop might just explode. So no highlights, as much as I would like to highlight things for you. We're here in paragraph 8. Plaintiff Lily Bernard brings the herein action alleging blank abuse, right? Assault and battery, persistent too, and she notes the applicable law. Okay. Now she gets into what she's alleging happened. Miss Bernard and William Cosby first met on the set of Mr. Cosby's television show, The Cosby Show. In approximately July of 1990, Mr. Cosby offered to be a mentor for Miss Bernard's acting career. I want to ask everyone in the chat a question. Let's have a little fun for a second, shall we? Not to say that this is at all funny, okay? No, these allegations are not funny. When we hear that Bill Cosby allegedly offered to mentor Lily Bernard and to help her with her acting career, does that sound similar to another celebrity, male celebrity, with similar accusations against him that we've discussed on this channel? I'll give you all a moment. Does it sound familiar at all to you? I will give you a moment. Let's see who gets it. And by the way, the person who gets it, I'm actually going to think of something really cool to give you as a prize. So, does this sound at all like another male celebrity that we have discussed? Oh, somebody got it. Octavius Prime got it. R. Kelly. R. Kelly. This sounds reminiscent of the R. Kelly victims talking about being promised mentorship. And then all of a sudden they were in a totally different situation, right? Yeah. Octavius Prime, you got it. Okay. Moving on. Paragraph 11. For the next several weeks, Mr. Cosby mentored Miss Bernard by, among other things, running theatrical exercises with Miss Bernard, asking her detailed questions about her life, and telling her that if she worked hard and followed his directions, he would feature her in a principal speaking role on The Cosby Show. Interesting. Okay, so she's alleging that Bill Cosby offered to be her mentor and that he proceeded to, take steps that led her to believe that he was interested in her career. Okay. Paragraph 12. During the mentoring sessions, Mr. Cosby stated that he looked upon Miss Bernard as if she were his daughter. Okay. Emphasized to Miss Bernard that chastity was a virtue. Interesting. Warned her of blank pressures of Hollywood and offered to Miss Bernard that she may call him daddy. Oh my goodness. Y'all, go back to Octavius Prime's answer. Okay. And tell me that these allegations aren't, giving you deja vu. Paragraph 13. During one of the mentoring sessions towards the end of July 1990, while Mr. Cosby was guiding Miss Bernard through a theatrical exercise in vocal projection, Mr. Cosby grabbed Miss Bernard's rib cage and diaphragm without her permission, under the guise that he was teaching her how to breathe, and then suddenly and violently and without permission, grabbed and squeezed Miss Bernard's breast. Interesting. Okay, paragraph 14. When Miss Bernard confronted Mr. Cosby about his inappropriate and unpermitted sexual... Oh, Miss Algorithm has already slayed us, y'all. We are laying upon the battlefield. We're done. About his inappropriate and unpermitted blank contact, he feigned innocence and acted insulted. Miss Bernard did not know what to think about what transpired. So pause for a moment. She's alleging that she was doing this exercise with him. He grabs her ribcage area, then allegedly grabs her breast. And then when she tries to call him out on it, he's like, huh? I don't know why would you? I didn't do that kind of thing. That's the allegation. And it's interesting that she says that because many victims of similar situations, right, when they make similar allegations, they say that. They say that in the beginning, they were made to feel like they were interpreting something that wasn't really happening, and the guy or the alleged predator would just say he didn't know what he was doing. He didn't mean to touch there. He didn't know he touched there, right? And then eventually it develops into something that's totally just out of hand, right? Um, I am checking in the chat to see it. Quack 13 says something very interesting. I have to highlight this because this is a very interesting conversation that we're about to have. So Quack 13 says, but didn't he deliver on that promise? Wasn't she on the show? So Quack 13, I'm actually glad you asked that question because we're about to have a very, very interesting conversation about blank harassment and harassment in the workplace. So did you all know that a boss, a superior, a supervisor, or someone that is above you in your industry, right, can be seen as harassing or coercing you if they come on to you in an intimate manner? Did you all know that? Give me a Y in the chat if you know or if you were aware that a superior in your industry, if you are considered to be quote unquote below them, whether that's less experienced or less paid or whatever, they can be considered to be harassing you if they come onto you in an intimate manner. Okay, everyone knows that. So, do you know why? Do you know why that is? Allow me to take you on a walk down the dynamics of power lane. I'm about to get really nerdy, so settle in. So, let's talk about the dynamics of power, psychology, and why it is that it's considered to be pressuring for someone who is so high above you to request intimate things from you. Here is why. If a boss says to a employee, hey, I like you, or even if the boss touches the employee's leg, the employee may not want to do whatever it is the boss wants to do, right? She may be thinking, I don't want to, but she will do it anyway. Why? Because she's afraid to lose her job, because she's afraid to be blacklisted, because she's afraid that if she says no to Bill Cosby, she'll never be able to get work in Hollywood again. So when you take this example and you put it, like I said, into the workplace, it's clearer for you. That is the reason that all of these workplace harassment laws exist, because it is understood that psychologically, when a superior asks you for something and they're in the same field as you feel coerced. You don't feel like you even have the right to say no, because psychologically you're thinking, no isn't an option. No could ruin me. So do you understand why him, quote unquote, delivering on the promise is irrelevant to this? Do you get it? Because if she did consent to anything, allegedly, she probably did so under psychological coercion, under this fear that, my God, what will happen to me if I say no? And that, everyone, is not true consent in the eyes of the law. Do we get it? Do we get it? Do we got it? If you get it, put a Y in the chat. I'll take a sip of water. Okay, I see the Y's rolling in. I see that we get it. I see that we get it. I had my nerd moment. Thank you, Quack 13, for my nerd moment. Okay. Mara Sharice and Trip C are having a tit for tat over some words. I won't say them since Mara's bothered by them. All righty. So let me remove this comment. If I can find it to remove it. Okay, once again, thanks to Quack 13 for that lovely walk down nerd lane. And let's hop back into it, shall we? Okay. Where were we? 15. Okay. In or about August 1990, Mr. Cosby persuaded, induced, enticed, and or coerced people. What did I just say about a superior and someone who is quote unquote below them? You see? Okay. Induced, enticed, and or coerced. Why I can't say and or today? And Wendell, and or coerced Miss Bernard to travel from New York to New Jersey by telling her that he was arranging a meeting at Trump Taj Mahal in Atlantic City between Miss Bernard, Mr. Cosby, and a man who Mr. Cosby described as a producer who would advance Miss Bernard's career. Interesting. 16. Oh, wait, let me stop there. Crime Spotter had a question. Crime Spotter was asking, is it possible that this producer, right, could be called to testify? Yes, that is absolutely possible. He could be called to verify that this meeting at the Trump Taj Mahal actually occurred. Okay. Mr. Cosby arranged for Miss Bernard's interstate transportation from New York to New Jersey. Upon information and belief, Mr. Cosby knowingly and intentionally transported Miss Bernard interstate. Oh, for the purpose of drugging and then blanking, man, Miss Algorithms got us, abusing Miss Bernard. So remember, we're in federal court. And we now are seeing more of the allegations that support us being in federal court. So we see that Ms. Bernard is alleging that Mr. Cosby knew all along, while he arranged for her to be transported from state to state, a la R. Kelly-esque, right? That he intended on harming her, that he intended on doing something illegal to her. That is the allegation. Okay. I am in the chat. Octavius has an interesting question. Black Godzilla says, is that similar to Rico? Well, we don't see any allegations that there was an enterprise, right? We don't see that type of allegation. Octavius Prime says, and by the way, Octavius, I meant it when I said you're going to get a prize. Email me. That's what I need you to do. Look in the description in Octavius Prime and send me an email, because we're going to set up something. All right. And what I'm going to start doing is creating little things to give away to people in the chat who, show up and give me these amazing questions and awesome answers, right? Because y'all deserve it. All right, so here we go. In these types of cases, wouldn't it be better to have an HR complaint or a police report in order to validate the harassment? Yes, it is always better to have some sort of paperwork to validate a complaint or a lawsuit, right? And so if in fact there is some sort of police report, that would definitely be useful. Hello, Saida Evans. Saida said something very interesting. She said, why do all these allegations take place at Trump hotels? I don't know. I will say this though, Saida. Remember that Trump establishments, I guess prior to Donald Trump actually being president, remember they were viewed as luxe. They were viewed as luxurious and for business people of a certain financial stature. Hence, people living in Trump Tower and people meeting in Trump hotels. It was more so seen as a status thing. So perhaps that's why. Okay, and also Trip C said he had a nice little corner of the hotel market at that time, which is also true. All right, so I'm getting back into the complaint. I don't see any questions, so I'm going to hop back in. Upon information and belief, Mr. Cosby knowingly and intentionally persuaded, induced, enticed, and or coerced. I got the and or down, y'all. Hey, we're doing big things. Miss Bernard to travel interstate for the purpose of blanking and then blanking Miss Bernard. The meeting continued past the meal and was moved to a dining room of one of Trump's Taj Mahal suites. So it sounds like they met in a restaurant portion, a public portion, and then the meeting was then moved to a suite. Okay. Once at the suite, Mr. Cosby prepared a supposedly non-alcoholic beverage for Miss Bernard to drink, since she did not drink alcoholic beverages. Interesting. Paragraph 21. After drinking the beverage, Miss Bernard began to feel symptoms of dizziness, an urge to vomit, and weakness. Mr. Cosby helped Miss Bernard to the restroom, where he said, "Daddy's going to get you something to feel better," before leaving the room. She thereafter vomited and lost consciousness. Well, these are some interesting allegations here. Okay. Interesting. When Miss Bernard awoke, Mr. Cosby was undressing her, and she remained dizzy, unable to stand and unable to move her body. Paragraph 24. When Miss Bernard said no in response to Mr. Cosby's efforts to undress her, interesting. So it looks like the plaintiff here is alleging that she actually said no. She actually said the word no. So she didn't even express consent, allegedly. When Miss Bernard said no in response to Mr. Cosby's efforts to undress her, Mr. Cosby ignored her and continued. She lost consciousness again. Miss Bernard awoke again to find Mr. Cosby. I won't say that. I also will not say that, but you see it. Miss Bernard lost consciousness again. So she alleges that when she awoke, Mr. Cosby was assaulting her in an intimate manner. Okay. Paragraph 26. When Miss Bernard awoke again, she found herself naked and alone in an empty bathtub in the bathroom, still dizzy and unable to move. She went in and out of consciousness until fully losing consciousness again. When Miss Bernard next awoke, it was morning and she was naked in a bed. Upon her awakening, Mr. Cosby dragged Miss Bernard to a sitting position, dressed her quickly, handed Miss Bernard money, and walked her to a waiting car with the assistance of a bellman. Mr. Cosby arranged for Miss Bernard's interstate transportation from New Jersey back to New York. I'm going to hop in the chat to see what's going on and see if you all have any questions. All right, so Fab540 says, how is it that her claim didn't make the first trial? Well, remember, he wasn't on trial for her allegations. And so everyone else who did testify during that trial, they sort of testified as we've discussed on the channel before, to prove a pattern of behavior. So who knows? Maybe she wasn't asked to testify at that trial. Maybe she chose not to. But being that he was not being prosecuted for allegedly doing anything to her, she wasn't really required to be there. Okay. All righty, I'm going to hop back into the complaint so we can round it on up because I don't see any other questions. All right. Whew, here we go. Paragraph 30. Mr. Cosby blank assaulted, battered, and drugged Miss Bernard on additional occasions. I'm sorry to read it that way, but huh? Okay. Paragraph 31. Following the blank assault of Miss Bernard by Mr. Cosby threatened plaintiff that if she went to the police, he would file a police report against her for false accusations and sue her for defamation. Following the blank assault of Miss Bernard by Mr. Cosby threatened that he would prevent Miss Bernard. What did I tell? I have to stop and have a personality jumping out moment. What did I just tell y'all? Didn't we just have the conversation about coercion and intimidation and superiors in industries? All right, here we go. Mr. Cosby threatened that he would prevent Miss Bernard from working in the entertainment industry if she reported the abuse. Following the assault of Miss Bernard by Mr. Cosby threatened Miss Bernard that he would erase her if she reported the abuse. As a result of the above abuse, Miss Bernard sustained physical, mental, and psychological trauma. Remember, a plaintiff has to establish damages, right? Let me back it up a minute. A plaintiff has to establish injury. That is a part of them having standing and a part of them being awarded damages. So that is why she is detailing that she suffered physical, emotional, and psychological trauma. All right, I see a question from Jaded Empora. Jaded Empora says, if this is civil and they prevail, can they charge him criminally? Maybe, right? Maybe some things come out in the civil case that are useful in the criminal arena. Remember, in Bill Cosby's last criminal prosecution, they used depositions from a civil case. So yes, Jaded Empora, maybe some things come out in this trial that prosecution finds to be useful. Okay. And Mara Cherise did make a good point. If statute of limitations has run out, they cannot technically. But you all remember, this would be a federal prosecution because she's alleging transportation interstate, right? So this could be a federal prosecution. It very well could be. And remember that federal agencies have more wiggle room with the statute of limitations, particularly with these types of cases. Okay, remember that. Remember, they have specifically created memorandums and spaces which allow them to stretch statutes of limitations based upon how egregious the crime is. All right, let's get back into it. Let's see, here I am, 35. By reason of the wrongful acts of Mr. Cosby, as specified above, Miss Bernard sustained permanent injuries. Remember, she has to detail this. Post-traumatic stress disorder, anxiety, depression, emotional distress, physical, we don't know what that is, nightmares, flashbacks, inability to sleep, severe physical pain and suffering, severe emotional pain and suffering, embarrassment, and multiple other permanent injuries. Everyone, teaching moment. Why is it important that she say her injuries are permanent? I don't think anyone's going to guess that, so I'll answer it. It's important that she say her injuries are permanent because she's establishing that this incident has forever lowered her quality of life, her standard of life. And that, everyone, is the ticket to a nice, healthy award of damages. Got it? Got it. All right. Oh, goodness. My laptop's on 7%. I'm going to need to relocate to the charger in a moment. Okay. 36. How many pages do we have in this complaint, though? I don't know. Maybe we can wrap it up. Let's see. 36. Among information and belief, her injuries are permanent. Okay. Oh, I see it there already. And or will expend sums of money for treatment. So not only damages just in for her own use, right? But also to be used towards treatment. I am going to grab my laptop charger, everyone, because we're at 6%. In the meantime, tell me in the chat, what are you all thinking of this lawsuit thus far? You know, do you think it has teeth? Do you see it being successful? Or do you think that Bill Cosby may be able to get some high-powered lawyers to make this go away? I don't see anyone giving me any thoughts on this. So no thoughts on whether or not this lawsuit will actually make it, whether it could be successful? Okay, Octavius Prime says he thinks that it would more than likely end in settlement. Perhaps. Perhaps. All right, so let's get back into it. Okay, so first count, assault. Okay, so she's alleging that Bill Cosby assaulted her, right? And we've heard the facts that go into that allegation. Okay. And we see her just using the legalese for assault. That's all she's doing in this section because she's already given us the alleged facts that support this, right? So those allegations have been made. What she's doing here is just giving the law, giving the legalese that would make her allegations fit the required statutory elements for assault. Okay, so that's why you see her here just pushing out the legalese there. Okay. We see here, though, that she has what is sometimes referred to as a prayer for relief. So it is what the plaintiff hopes to attain. And we see here in particular that she is hoping to be awarded damages in an amount no less than $25 million. All righty then. Second count, battery. Again, she has already given us the alleged facts for this, so she's not going to regurgitate that. She's just going to add the legalese that would fit the statute for battery. Hence why she discusses non-consensual contact in paragraph 44. So that's all this is here, just backing it up with the legal terms. She goes in again with her prayer for relief and says that she would like damages in an amount no less than 25 million. Notice she repeats that for each count. Okay, remember that. So remember, she's not asking for a flat 25 million. Okay. Alrighty. Third, intentional infliction of emotional distress. Yet again, she has already given us the alleged facts. So all she does here is put the legalese in, put the statute into her complaint. So check out paragraph 50, right? She says the foregoing actions of defendant, i.e. Bill Cosby, were done with the intention to produce emotional distress. So she's saying, hey, listen, in accordance with intentional infliction of emotional distress, I am alleging that Bill Cosby intended to cause me emotional distress when he did what he did. Okay. Goes further. And then, of course, she has her prayer of relief again with 25 million. Okay. False imprisonment. Same process as all of the other counts. And then she inserts the legal terms. So you see here in paragraph 57, through the aforementioned conduct, Mr. Cosby unlawfully restrained Miss Bernard. That is the literal statute for false imprisonment. So once more, right? In the beginning, she gave us her allegations. And now for each count, she's just putting in the law. And mind you, of course, she didn't do this herself. Her attorney did this, but we say she because she's the plaintiff, Miss Bernard. Okay. And again, her prayer for relief, 25 million. Okay. Fifth count, she goes into punitive damages. She discusses the conduct by Mr. Cosby, which she thinks warrant that punitive damages be granted. Right. And for those of you who are unaware, because I wasn't going to get into it, but I think that some of you may not actually be aware of, like what punitive damages are and what the purpose of punitive damages are and things like that. So let's have a conversation. So notice that punitive starts with PUNI, right? Like punishment. That's not a coincidence, everyone. So the reason why she goes in this section about Mr. Cosby allegedly being malicious and doing things, willfully doing harmful things, because for this section in particular, she is asking the court to award her damages that are in fact a punishment for Mr. Cosby. So not damages really based upon anything else within the case, but more so based upon telling Mr. Cosby what you did was wrong, right? So money solely for the purpose of punishing him for alleged wrongful behavior. That is punitive damages, damages that are for the purpose of punishment and not necessarily related to injury. Octavius Prime has an interesting question. He said, why are federal lawsuits done in the form of a prayer? So the prayer for relief is what it's called. And it's the section where the plaintiff says to the court, like I said, all these things have happened. And now, Your Honor, I would like to be awarded this in exchange for, whatever it is that has happened to me. Okay. All right. So someone said that he thought it was 250 million. Did I read it wrong? Was I tripping? No, I see 25. I don't know. Okay. Alrighty, so punitive damages, we've covered that, okay? And here now we see that in punitive damages, she is requesting 125, okay? Alrighty. And then we see her attorney, of course, signed off on this and it was submitted, okay? So we have covered her entire complaint. Now, let me just make sure. Okay, so I'm going to stop sharing my screen. Sometimes I make random little thinking out loud noises. I'm sure everyone does that. So everyone, we have covered the entirety of the Bill Cosby federal lawsuit. We are now at 7:40, which means we're, an hour and 10-ish. And I'm going to start taking some questions. So I see a question from Mara Charisse about the burden of proof in this case. So I'm going to bring up for you all, hopefully the LII has something that explains that, because I would love to. Is this it? Yes, here we go. All right, so I'm going to share my screen and we're going to talk about the burden of proof in civil cases, i.e. the burden of proof that Lily Bernard has in this case. If you are a newbie here, the person who brings the case, be it a prosecutor in a criminal case or a plaintiff in a civil case, has the burden of proof, meaning they have the responsibility of showing evidence to support whatever it is that they're alleging. Okay. All righty. So I'm going to share my screen. Chrome tab. All right. So here we are back at the LII. Burden of proof. All right. So they have a section here where they discuss the burden of proof in civil cases. Did I miss it already? Oh, here we go. Let's start from the top. Burden of proof describes a standard that a party seeking to prove a fact in court must satisfy, right? Just as we discussed. Now, in criminal cases, that is beyond a reasonable doubt. We know that. In civil cases, the plaintiff has the burden of proving his or her case by a preponderance of the evidence. A preponderance of the evidence and beyond a reasonable doubt are, of course, different standards, right? Now, for those of you who don't know, preponderance of the evidence is a lower standard than beyond a reasonable doubt. Okay, it's not as high. Okay, so here we have it. So under the preponderance standard, the burden of proof is met when the burdener, right, convinces the fact finder that there is a greater than 50% chance that the claim is true. So in other words, Ms. Bernard has to prove that it is at least 51% possible that what she alleges Mr. Cosby did to her, he actually did. And why is that a lower burden than beyond a reasonable doubt? Well, I'll tell you why. Because beyond a reasonable doubt, although it's not 100%, right? It is very, very close to 100%. Beyond a reasonable doubt pretty much says to the exclusion of, right? Beyond every other reasonable version of events, the prosecutor has to prove that their version of events is what happened. That's not what we have here. Here we have that Miss Bernard just has to prove that more than likely, right? 51%, more than likely this happened. Got it? All right, I'm going to go into the chat here. I do not see any other questions. Are there any questions about the Cosby lawsuit? Because if not, we are going to go ahead and call it a night. Going once, going twice, going once. All right, I don't see any questions. So listen. Oh, actually, we got one. That question isn't okay. Well, let's walk down this path. Okay, let's walk down the path. So Rich says this person is trying to get paid. That's it, and that's all. Isn't this like extortion? A civil lawsuit is never extortion. Okay, extortion is not a civil lawsuit. When you file a civil lawsuit, you're a plaintiff. Okay. Alrighty, so I do not see any other questions. Oh, Mara Charisse has a little topic recommendation for me. So Mara Charisse says, I really appreciate you covering this. Of course, darling. Are you going to cover Theranos? Mara, can you send me let me put my email in the chat for you all. Because Octavius Prime, I need you to email me. It's also in the description of this video as well, but I'm going to put it in the chat. Mara, please email me some information on this Theranos situation. Okay. Thank you to K Business Podcast for the $5 super sticker. Thank you very much. We appreciate it. You guys check out K Business Podcast. He is awesome. He covers entrepreneurship and he's real. You know, he gives you real practical advice. So check him out. And as Nappy Yankee said, please like the video, share the video, and subscribe to the channel. Crime Spotter said Ghislaine. I think it's Ghislaine. Ghislaine Maxwell's trial is coming up next month. Absolutely. I think we're definitely going to be covering that on this channel. I think we're going to have to dive into that for sure, for sure. All right, everyone. So listen, it has been wonderful being with you on this Saturday night. As you all know, we love to arm you with legal knowledge here. And so I hope you feel empowered and amazing because you are. And remember, if there is something that you are striving for, if you have in your mind and in your heart this vision and this dream, you owe it to yourself to try and not to let anyone else discourage you. So it's been nice, and I hope to see you again soon. And if you're catching this on the replay, what say you? What do you think of, this demand for alibi in Michael Nowak's case? What do you think of this federal lawsuit? I'd love to hear your thoughts. Bye, everyone.